Swayam Prabha. Digital India. Educated India.
Welcome dear students. Today we discuss one of the important topic of corporate finance, shareholders' rights in individual capacity and corporate capacity. I am Dr. Jaswant Saini, Associate Professor, Faculty of Law, MD, University Rohtak, present this topic before you. Shareholders play a very important role in the functioning of any company. Shareholders are considered as a member when their names enter into the company members register, and they exercise their power in two different capacities, one in the individual capacity, second in the group, it means corporate capacity. So, as usual we start every discussion with the learning outcomes, and very first learning outcome of the entire discussion is here to understand the legal framework of the Companies Act 2013 that governs and protect shareholders' individual and collective rights. Company Act 2013 designed to protect the interest of investors in corporate law, in business law, in securities, in stock exchanges. Second one, to understand and evaluate the impact of shareholders' rights and collective membership rights on corporate governance practices. Corporate governance practices governed by the corporate participation, and the members participate with different capacities, in individual capacity or in corporate capacity, means in group. Third one, to learn about the specific rights which individual shareholders possess, and they are voting rights, dividend rights, and contest the election of directors, so many others. And fourth one is to learn about the power of collective action as shareholders, including the ability to requisition meetings and seek relief against oppression or mismanagement. So, introductory parts start here with the shareholders' importance. A shareholder, commonly referred to as stockholder, and is any person. The shareholders definition start with any person. That may be an artificial person or natural born person. A company also become a person in another company, or a institution may be represent as a person in the company. Who owned at least one share of the company's stock, they are treated as shareholders. There is immaterial thing how many shares you hold. Material thing is here, your participation should be there. If you participate in the decisions of corporate body, either you hold one share, either you hold 1 lakh shares, that is immaterial. Material thing is here, you participate in the holdings, you participate in the shareholdings. They are partial owner of company and are entitled to a share in the profit that the said company generates. You are partial owner in the company's ownership or company's dividend or company generate the profit. You participate in the capacity of members. So, net profit are provided to stockholders by way of dividend. If company earn the profit in any financial year, you will be entitled for dividend, but one rider is here. If company not declare the dividend, then you not participate in the dividend. Two things here: company earn the profit in the financial year, second, company declare the profit. So distribution of profit or participate in profit, you are right if company declare the profit, if company declare the dividend, or through an increase in stock valuation. Second important thing is here, if company is a profit making company, no doubt the reputation of the company well established in the market, and reputation always reflected in the form of value of share in the stock exchange if the stocks are listed in stock exchange of particular company. If stocks are not listed in stock exchange, so it's very difficult to judge the value of that company, and generally we consider value of the company from the value of shares. If the value of share of any company in the stock exchange on higher side, generally we create a perception the company is a dividend earning company, company is a profit earning company, and the reputation of company, you may be say goodwill of the company on higher side in the business cycle. So shareholders play a vital role in corporate governance through participating in decision making process. Decision making process is the important process. Being a artificial person, company fail to take any decision without the involvement of human being. When human being involved, they take the decision in the meetings, and in the meetings that decision making process perform, and the members participate in decision making process. Either there is an annual general meeting or the extraordinary general meeting, members decide the fate of the company. Members decide policies of the company. Members take the necessary decisions to implement the policies, to implement the public policy. So members are here responsible to take each and every decision on the behalf of company, being a owner of the company, and they become the owner due to participation in the stocks, due to participation in the share capital. So voting rights they exercise in the meetings and influencing overall direction of the company. So members are such persons who decide the policies of the company in AGM or extraordinary general meeting, and this is the important right of the members. They cast their vote on each and every matter of the company if that matters present before them. So they play very important role. Members play very important role in the functioning of company through participation in decision making process. Shareholders meaning and features: first of all, they are the owners of the company property. Shareholders own a portion of the company's capital in proportionate to the number of shares they hold. If they hold the 10% of share of the company out of total share capital of the company, it means they own the 10% ownership of the company. So basic idea is here, the ownership in proportionate of holding of shares, and your voting right in proportionate of holding of shares, and you cast your vote in proportionate of your representation in the share capital. So the ownership stakes gives them certain rights. If you are the owner of the company, through participation in share capital, you own certain rights. Certain rights are applicable. Claim to the company's assets and profits. You participate in the company profit, you participate in company asset. Basically, we say here participate in company asset when the company going in winding up. All the property converted into cash and that's distribute among the members in proportionate of their holding. Financial interests. Shareholders have a financial interest in the company's performance. If company earn maximum profit, they participate in the profit in maximum side. If the company not earn the profit, it means they not participate. So financial interest also involved of the shareholders in company performance. If company perform well, their value of the shares increase in the market and they are entitled for more and more dividends, and they benefit from capital appreciation. Capital appreciation means value of the shares increase, dividends and other financial returns generated by the company. So if company is a sound going concern and company earn the profit and every year they earn the profit, they may be provide bonus shares also to their members, and bonus shares offered only to existing members, and that's in lieu of dividend not allowed. Without cash, when the other shares are given to the existing members, that's known as bonus shares. So many other benefits to the existing members. If company declare the right issue, then they are also entitled to get the shares in the form of right issue after pay the nominal amount as decided by the company. So another rights that reflected on the part of members, they voting rights. Shareholders typically have the right to vote on significant corporate matters such as the appointment of directors, mergers and acquisitions, and change to the company's constitution. So basically here 5 decisions taken by a company in different circumstances, and these all decisions reflect here the power of shareholders. Members, when decide these policies in the general meeting or extraordinary general meeting, they appoint or remove the directors. They decide the merger, acquisition or reconstruction of the company. And if a company decide to acquire the share of another company, that also decided in general meeting. And changes of the company's constitution. Changes means every type of changes, and company constitution means some certain set rules which reflected in the form of article of association and memorandum of association. They may be changed by the company with the consent of members, and members take all these decisions in the meetings. So risk and reward, that also relates with the company's ownership. Shareholders share in the companies involve the risk and rewards. If company in drawn side there is a no profit and company only on the loss and loss, company not perform very well, it means that's the risk on the part of owners. Shareholders are the owners of the company property. Rewards means if company is a profit making company, company is a sound concern, company is a blue chip company, the appreciation of value of shares is also a reward for the shareholders. If the company perform well, shareholders may see an increase in the value of their investment. When value of their investment increase, that's appreciation of the money. That's the rewards to the shareholders, and that type of rewards everyone attract to the others. It means flow of capital through this reward of investment. If company going sound concern and profit making company, that's also competitor company try to perform on the same pattern, whereas poor performance of company may lead to a decline in the value of its share value. So decline in the value of shares, that means company is not a going concern or not a profit making concern. If value of the share increase in the market, it means company a profit making company. So these are the risk and reward for the shareholders. If company perform well, their appreciation of money. If company decline, decrease of value of money. So, that is the risk and reward involved with the ownership. So, liability is limited or unlimited, that also relates with the ownership or participate in the share capital of the company. In case of limited liability companies, shareholders' liability is usually limited to the amount invested in shares. For example, Mr. A buy 1000 share of any company of 10 rupees each, it means he apply 10,000 rupees in this company. And their liability of this gentleman, Mr. A who buy the 1000 share of 10 rupees each and he invests 10,000 rupees, the liability is comes to be an end if he pay the whole amount to the company. If he pay partial amount, means 5,000 pay and 5,000 remaining. So, the liability of the shareholders up to unpaid share part. Liability is here only up to unpaid share part. If you pay the entire amount, then there is no any liability. If your amount is left or need to be paid on the demand or at the time of call, it means your liability up to unpaid share part. These personal assets are protected from the company's liability, and in case of company, you are only liable up to investment part, investment ratio. So, the personal assets are protected from the company's liabilities. So, types of shareholders, here various types of shareholders. Individual shareholders means investor who purchase shares in their personal capacity. If you purchase the share in different capacity, you reflect the different identity. But if you purchase the shares in personal capacity, you are considered as individual shareholder. Institutional shareholders, these are financial institutions, these are banks, these are insurance companies and mutual fund who invest large sums on behalf of their clients. Financial institutions, for example, LIC, GIC, they invest if in the any company, they invest in the corporate capacity. Banks and financial institution, when invest, they invest in corporate capacity. Insurance companies invest in their institutional capacity, and mutual funds are funds which are established for this particular purpose. They pool the money, they arrange the money by sale of units and apply in the security market for the interest of their investors. So, promoters is also a shareholders. These are the individual or corporate entities. In both capacities, you may act as an shareholder, as a promoter in individual capacity or in corporate entities capacity, who played a significant role in the formation of the companies and often hold a substantial number of shares. That's depend on the nature of the business and the intention of the promoters, how much amount they want or decided to invest in the particular company. Sometimes an individual may be act as promoter, sometimes a company may promote the another company, or a corporate entities, corporate body may act as promoter for the rest of the purpose. So, we discuss in detail later on what is the lock-in period when the promoters apply their funds in any company. So, another shareholders are retail shareholders. There are small individual investors who buy a relatively small number of shares from the open market, and in this direction SEBI laid down who buy 1000 share or less than 1000 shares in any company in any financial year, that considered as small shareholder or retail investor or retail shareholder. The limit is here 1000 shares or 20,000 rupees, whichever is less. That shares treated as retail shareholders, and that is known as retail investors. Majority shareholders, these are shareholders or group of shareholders who hold more than 50% of the total shares, giving them significant control over decision making in the company. We consider the majority or minority with the holding of shares. If any person hold 50% or more, it means substantial portion in their control, and that's considered as major shareholder, and majority shares in their control. Substantial shareholders are the person having an interest in not less than 5% of the nominal amount of the voting shares in a company. So, in this regard, 5% of the nominal amount of shares, if in one hand, that person is known as substantial shareholder, not considered as majority shareholder, substantial. Substantial word indicate that he maybe affect the decision of the company, because he hold a major part out of this entire share capital or total share capital. And minority shareholders, these are shareholders who hold less than 50% of the shares. So, like other institutions, we decide the majority and minority on the basis of holding of shares. More than 50%, it means majority. Less than 50%, it means minority. If you hold 5% or more, you are substantial shareholder. So, there are the different capacities of a shareholder. Preferential shareholders or preference shareholders get fixed rate of dividend. So, various type of preferential shares here, we discuss later on this aspect also, but presently we discuss how equity shares are different with the preference shares. Preference shares are those shares who claim preference at two times, one at the time of dividend, second at the time of winding up. When at two places preference given to those shareholders, those known as preferential shareholders. And second thing is here, fixed rate of dividend given to the preferential shareholder. They get preferential position over equity shares. Preferential on whom? Preferential on equity shares. It means in comparison of equity shares, preference given to them. Capital with respect to payment of dividends and repayment of capital at the liquidation of the company. So, preference given at two times, at the time of dividend and at the time of winding up. If two times you gave the preference, you are considered as preferential shares. If this preference not given, you are equity shareholders. So, preference with whom? Preference with equity shares. Preference shareholder has the right to vote only on those resolutions, which related to preferential nature. If matter not related to preferential nature, then these preferential shareholders not entitled to cast their vote. But one technical glitch here, if in 2 financial year company not earn the profit and not gave the dividend to the preferential shareholders, then they are treated as equivalent to equity shareholders, and then they cast their vote on each and every matter. So, particularly or in majority of the cases, if company earn the profit and deliver to the preferential shareholders as a dividend, then they are not allowed to cast their vote in spite of their preferential nature matters. But apart from them, if company not earn the profit and fail to give the dividend in 2 consecutive financial years to the preferential shareholders, their status automatically become equivalent to equity shareholders. The issue of preferential shares does not create any charge on the assets of the company. The charge always create on the debentures. The preferential shares if issued by the company, generally there is no any charge, or usually there is no any charge. The issue of preferential share does not create any charge. Certificate of charge issued by the registrar of companies, and this certificate certified that that's collateral security created by the company for ensuring the repayment process. So, the important thing is here, charge never create on the part of company if company issue the preferential shares. Charge only create if there is a debentures issued by the company. So, preference shares are an important source of long term finance. So, that is source of long term finance, because company return the amount of preferential shareholders as per the terms of agreement. So, they use this money as per the terms of offer document. Equity shareholders. Equity shareholders, in comparison of preferential shareholders, their right to claim dividend and participate in assets are secondary right, and first right given to preferential shareholders. So, equity shareholders have the right to vote in meeting of shareholders in each and every matter. Dividend is paid to equity shareholders after payment of dividend to preferential shareholders. So, this thing certified that equity shareholders rights it second, and they are the real owner of the company property, because they claim at the end and their claim becomes secondary first claim of the preferential shareholders. So, real owner of the company's properties are equity shareholders, and after pay the dividend to preferential shareholders, if remain, then they participate in the dividend, otherwise not participate in the dividend. And these are investors. Equity shareholders are considered as investors who ready to take risk of higher returns. Owners always ready to take risk, and which type of risk? High returns. Because preferential shareholders only entitle up to the fixed rate of dividend, which already decided at the time of issue of these shares, and there is no any limit on the part of equity shares. Equity shareholders entitle for any amount of return, that's total depend on discretion of the board of directors. So, board of directors decide how much returns given to the equity shareholders, there is no any limit, but limit is exercise, limit is applicable on the part of preferential shareholders. Equity shareholders enjoy limited liability. That is the important feature when company start its business, company become a incorporated body, company obtain the certificate of incorporation, that is the limited liability concept start. Limited liability means your liability up to the extent of unpaid share part. If you pay the whole amount against your number of shares, against your investment, it means your liability comes to an end, which means that their liability is restricted to the amount invested in the shares. So, this is the very clear from this discussion that equity shareholders are the owner and they are liable up to the extent of unpaid share part, and beyond this they are not personally liable for any activity of the company. If company doing business well, they participate in the profit as a dividend participator. If company not earn the profit, there is no any appreciation of the money, the risk is attached with the same. And you know it's very well, where there is an application of money in the market, risk always attached with the market. and market forces decide the risk. Market forces decide the value of investment. Market factors decide the other things. So, members under the Company Act 2013, that is defined by section 255 of the Companies Act 2013. Member in relation to a company means the subscriber to the memorandum of company who ready to subscribe the memorandum of association, that's automatically become the members when company obtain the certificate of incorporation. Who shall be deemed to have agreed to become member of the company? When you sign on the memorandum of association, that's deems to be you agree to become the member of the company. And against your name, how much number of shares reflected, you agree to buy such shares and you automatically become member after acquire the certificate of incorporation by the company. And on registration, registration word is not a appropriate, actual word is here incorporation, but this word inserted here to develop your understanding here. Generally, incorporation and registration both are similar things. They are the synonym of each other. But in literal sense, in legal terms, the actual term is here incorporation of the company. Registration word basically we attach with the partnership forms. So, on the incorporation shall be entered as members in the register of members. When your name enter into the company's member register, you automatically become the member. So, for your knowledge point of view, I highlight here two things here. There is a lot of difference between shareholder and member. When someone is a shareholder, it means he purchased the share of the company, but he is not member. The person become member when his or her name enter into the company's member register, then the person is considered as member. If his or her name not reflected in company's member register, he is never treated as member. All rights are available to the members, only one right is available to shareholders for transfer of name. So, every person holding shares of a company and whose name is entered as a beneficial owner in the records of depository. Now, after 1996, when the Depository Act 1996 introduced in the Indian scenario, nowadays Depositories Act for the purpose of buying and selling of securities, for the purpose of transfer of name in the securities. In such cases, code of depository reflect the name as a beneficial owner shall be deemed to be a member of the concerned company. In a depository participant record, your name is reflected as a beneficial owner, you will be considered as member of that company. That is automatically presumed that you are the member. A company is an association of members. In the features, when we discuss the features of the company, it means company a association of members. Here also the group of persons called as association. So, whose group? Members group. Member, who are the member? Who buy the shares of the company. So, automatically who hold the share, they are the members. But in literal sense, you become the member when your name enter into the company's members record, company's member register, though it has its own separate legal entity. When you become the member, you are entitled for various rights. If you are not entered into the company's member record, company's member register, you are not entitled for any right except one, you only apply for transfer of name. The members of a company are the persons who constitute the company for achieving the objects as decided by memorandum of association. So, the object where decided, object decided in memorandum of association, and they decide the policies according to the object and memorandum of association and public policy and laws which applicable on particular time, which prevailing at the particular time. So, the term members and shareholders are usually seem to be same. We use word here usually seem to be same, but there are lot of difference. I already highlight before you the difference between shareholder and members. Also, there can be no membership except through the medium of shareholding. If your name not reflected in company member register, you are not become the member. You are not considered as shareholders. So, there is only one method to become the members. You should own the shares. And how you own the shares? Through buying of the shares or through transmission of shares. If you are the legal heirs of someone and in case of death you entitle for those shares, then those shares comes on your name through transmission of shares. So, due to the same you also become the member in a company. So, there are two process here, one is transfer, another is transmission, and third one, if you buy the shares through primary market, you directly become the member of the company. So, there are the various rights here in this chart, and these are the shareholders' right in individual capacity. In individual capacity, shareholder receive of the copies of the document. Any document which available in the company's office, you may receive the copies of such documents after pay the nominal fee which prescribed by the company itself or the legal requirement or the statute books define the fee of the obtaining copies of the document. And in personal capacity, in individual capacity, that is your right, you attend the meeting. Any type of meeting which designed for the members, you participate as a matter of right, and that is your individual membership right. And third one here, you contest the election. Election of whom? Election of directors. You are hereby in individual capacity contest the election of director, and through this election you participate in management also. You participate in decision making when you participate in meetings. If you become the director after contest the election, it means you participate in management also. And you claim dividend, but some rider is applicable here. In case of dividend, first company declare the dividend, then you are allowed to claim the dividend as a matter of right. If company not declare the dividend, you never claim as a matter of right this dividend, and you are not entitled to claim dividend. So, two things are here attached with this claiming of dividend. One, company earn the profit in particular financial year. Second, company claim the dividend. And the right of inspect statutory register and returns. That is the foremost important right here. Being a owner, being a member of the company, you inspect any register or returns of the company. If company maintain their register and record of such documents. If company or statutes define some fees for the same, you are bound to be paid such fees. If there is no any fee, then without payment of fee you may be inspect being a owner, being a member. So, individual rights of shareholders are reflected in chart also already we discussed, and some of them is here. Member of a company enjoy various rights in his or her individual capacity. These rights are contractual rights. You may enforce these rights as a contractual rights, because when you become the member, we presume that you sign the memorandum of association and article of association, and that is applicable as a contract among the company and members. So these rights are contractual rights and cannot be taken away except with the written consent of the members concerned. If members consented for withdraw these rights, then the different rules are applicable, different propositions are applicable. Unless and until you withdraw your rights, you exercise these rights. These rights can be categorized in different categories, and some of them here highlighted here: right to receive copies, right to inspect statutory registers, right to attend meetings, and other rights. So various other rights also attached with the same. If you are the members, you enjoy these rights. So right to receive copies of the document from the company, a copy of the financial statement including consolidated financial statement, if any. If any means if company prepare, then you obtain the copies. If company not prepare consolidated statement, then company not prepare on your request. Auditor's report and every other document required by law to be annexed or attached to the financial statement as per section 136, you are allowed to be obtain the copy of the same from the company. And abridged financial statement and auditor report which reflected in section 136, in brief, abridged means in brief, if auditor reports and statement in case of listed company, you are supposed to be submit to the stock exchanges these returns and copies. A member maybe take the extracts of these documents, this record. Report of the cost auditor, if so directed by the government. If government directed to any company to prepare the cost audit report, then if this report prepared by the company, you may be obtain the copy of the same. Notices of the journal meeting of the company which reflected in section 101 and 102. In case of company or in case of any institution, notices play very important role. That is also the requirement of one principle of natural justice. You not take any action without give the notice to them. So notice is an essential requirement to take action against anyone. So notice of journal meeting or extraordinary journal meeting or every type of activities which presented before the members in their meeting, notice should be there. And notice of journal meetings, members may take copies of the same if required. Right to inspect statutory registers, returns and get extract. The members have been given right to inspect the following registers. On the basis of these sections, they are authorized through these sections. Debenture trust deed which reflected in section 71, you may take copy of the same. Any document which available in the company's record, which available in the company's office, you may claim the copy or extract of the same being a owner of the company. When you are shareholder, when you are member, you are considered as owner. And owners are never denied, declined or restricted to take the copies of the same. Register of charges on the instrument and instrument of charges. In case of company when issue the debentures or the loan, company take loan, then they create the charge against the company property. So the register of charge, you may take copy of the same or you may be inspect. Statutory register, every type of statutory register you may be inspect. Copies of contract of employment with managing or whole time directors, you may take copy. Shareholders minutes, that's if book maintained and recorded in section A119, you are entitled to take the copy of the same. Register of contracts, companies and firms in which directors are interested. Section 188 and 189 related to transactions, interested related transactions, where there are interest of the directors involved. Section 188 and 189 deals with the same, and you maybe take the copy of the same. Register of directors and key managerial person and their shareholdings in section 170, you may take copy of the same. So, particular in nutshell we say members are allowed to take the copies of statutory registers, return and extracts of these documents if they required. Right to attend meetings of the shareholders, section 96, 100, 105 and 107, right to attend meeting of the shareholder and exercise their voting right in these meetings. A proxy, if a members appoint a proxy basically to attend the meeting in lieu of his presence. If a member is not interested to attend the meeting, he may nominate any proxy. The proxy may be a member or not member. So, there is no any rule regarding the same. Proxy need not be a member of the company. So, any person may be act as proxy. Proxy can act on behalf of members not exceeding 50 and holding in the aggregate not more than 10% of the total share capital. There are two restrictions are applicable on proxy. So, we consider these restrictions also when conduct the meeting. Proxy shall not have the right to speak at the meeting. If you are only members, if you are members or in your capacity of members you speak in the meeting, but proxy are not allowed to speak in the meeting. They only attend the meeting. A proxy cannot vote on a show of hands. A proxy is not counted for the purpose of quorum. When we talking about the show of hands, it means one person, one vote count here. So, for this particular purpose, a proxy is not allowed. For the purpose of quorum, quorum basically indicate that minimum number of members we required to declare any meeting as a valid meeting. This quorum, when we consider, we only consider the members, those members who attend the meeting in their own capacity as a member. If in the capacity of proxy you attend the meeting, you are not counted as the purpose of quorum. A proxy has the right to attend the meeting. A proxy has the right to vote only on a poll. If there is a vote on poll, then proxy allowed. If show of hands, one of the mode of voting, then you are not allowed. In case of vote by poll, it means you represent number of shares. In case of show of hands, you present one person, one vote. In such cases, you are not allowed. So, there are the few restrictions are applicable on the proxy if they attend the meeting in the capacity of proxy. So, some other rights also available to the shareholder in his individual capacity. Very first, transfer of name. It means if you buy the share, that is your inherent right, you apply to the company for transfer of name. Register for increase his liability without consent. So, this is the important and vital right available to the members. If any time company increase your liability through meetings, in such cases you register to increase your liability. Claim right shares. If any time company declare the right issue, you claim as a matter of right, being a member. So, that is your individual capacity, you exercise this right. Right to nomination. Nomination is the important right here. In case of your inability or in case of death, who represent your property. Your shares, debentures also your property, and as per section 44, that is the movable property. So, right to nomination is very important right. A member may exercise this right in his individual capacity. Appeal to tribunal in the capacity of dissenting shareholder. If you are not agree with any decision of the company, then you may be appealed to the tribunal in the capacity of dissenting shareholders. This is your important right. Other individual rights of shareholders, Section 44 indicate that's movable property, shares, debenture and other securities, and you claim transfer of shares. 56 also relates with the same. Article of association of the company you may be obtained, and two rules are applicable on transfer of name. One is article of association, another one 44 and 56. According to section 44, they are the interested member may apply for transfer of name in movable property and resist and safeguard against increase in his liability, that's reflected in section 123. No dividend shall be paid by a company in respect of any share therein except to the registered shareholder. So, if you are the registered, your name reflected in company member registered, then you are entitled for the rest of the rights, otherwise you are not entitled for the other rights. So, right share you claim under section 62, and appoint director, you participate in the election of director in 152, and section 48 basically relates to class right. It means you, if any, you are the dissenting shareholders, being a class right holder, you may be applied to the tribunal. So, various rights are available to the person in his individual capacity. Section 210, right to be exercised through a group by passing a special resolution. Section 241, right to make application collectively. These are the collective membership right. Tribunal in case of oppression and mismanagement. And section 245, right to file class action suits before the tribunal. In your group, in your corporate capacity, you may be file a case before the tribunal. That's power given in section 245. Right of nomination reflected in section 72. Section 37, right to file a suit to take any other action in case of any misleading statement or the inclusion of omission or of any matter in the prospectus. If any wrong statement in prospectus as per section 37, you may file a suit. So, lot of rights are available to the person if his or her name reflected in company member register. So, collective membership right, basically in group you exercise, complaint against oppression and mismanagement, request for extraordinary general meeting and class action which reflected in section 48. So, these are the various rights you applicable or you apply or you claim as a matter of right in capacity of group, not in individual capacity. So, that's depend on the nature of activities, either they are covered under individual right, either they cover in corporate right. So, collective membership rights, number of companies here define these rights in their code of conduct. It means you code of conduct must you publish in the your website, and these rights also reflected in this code of conduct. Do and don't. You do these activities, you are not allowed to be doing these activities. Member of a company have certain rights which can be exercised by members collectively by means of democratic process. It means majority of members, if usually in the favor of the same, they exercise the same. If majority of the members not in the favor of the same, then they are not allowed to be exercised. So, collective membership rights when you apply in collective capacity. Application to the board in case of oppression and mismanagement. Section 241 and 244 particularly relates to oppression and mismanagement, and minimum number of 100 members. 100 members or 1/10 of total number of members, whichever is less can make an application for oppression or mismanagement. So, in companies without a share capital, these rules are applicable where the company is having a share capital. If company not having the share capital, then 1/5 of the total number of members exercise this right, which reflected in section 241 and 244. Make a requisition for calling the extraordinary general meeting, that's applicable in section 100. It means member holding not less than 1/10 of the total paid up share capital. That number of persons, members holding 1/10 of paid up share capital may be individual. Make a requisition for extraordinary general meeting. And board must respond within 21 days if such requisition made by the member. And requisition have a 3-month period. The company is bound to conduct the meeting within 3 months if rest of the conditions are fulfilled by the members. So now we are here, summarized part. Shareholders are integral element of corporate governance. Without shareholders, there is no any possibility of decisions, and members take decision in the meetings, and they actively shape the company's growth and the journey of the company by exercising their voting rights. Shareholder include individual investor, institutional investors, promoters, retail investors, and preferential shareholders. Each one play their distinct role in their application of rights. Individual shareholder rights are certain rights which they enjoy in their individual capacity, and some rights they enjoy in corporate capacity. Collective membership rights are certain rights which can be exercised by members in collective capacity by means of democratic process, means by majority of the persons when exercise these rights. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.